Morning, I'm Dan Mayhem, District Attorney for the 4th Judicial District. As you saw this morning, Crystal Lee pled guilty to a Class 6 felony, tampering with physical evidence. It carries a penalty in the presumptive range of up to 18 months in prison, in the aggravated range up to 3 years in prison, and that's by state law. By state law, it is not a mandatory sentencing type charge, so that actually the judge has a choice of anywhere from probation on up to that 3 years if the judge finds aggravation in this particular case. We have postponed sentencing until after any hearings or trials are done on any other related matters. Certainly that would include the Patrick Frazee charges at this time. He is presumed innocent unless until proven guilty beyond a reasonable doubt. We have agreed, though, by our agreement that she will not be sentenced until after all trials are completed. You heard the judge say that could be 6 months from now, that could be 2 years from now. We really don't know. She is to appear in the future periodically through reviews. The court has allowed her to do that by phone in those reviews until such time as we get up towards sentencing on her particular case. She did read into the record a factual basis, which is also required by Colorado law. I do have a copy of that, but I assume you've all got that on camera, and I don't necessarily need to repeat that. The judge put certain terms of the agreement on the record, such as she is required to cooperate in all cases. She is required to testify if called upon to testify in all cases. And in particular, obviously, he referenced the Patrick Frazee case that is currently set for February 19th for preliminary hearing at 9 o'clock. She is not allowed to talk to the press. That is actually part of our agreement, that she is not allowed to do that. So she will be making no comments at all to the press, or it'll be a violation of that agreement. Any questions that people have beyond that?
Dan, did she get off easy?
Why did Crystal throw away custody cell phones?
She indicated on the record that she, actually I'll give the specific phrasing that she said. She said, "I moved the victim's cell phone with the intent to impair the phone's availability in the investigation. I had no right or authority to move the victim's cell phone that occurred between November 24th and November 25th, 2018 in Teller County." And that's as much as she said today.
Has she able to give any indication what Patrick Frazee's motive was or where Kelsey's body may be?
All she said today on the record was, oops, I apologize, is that? I can wait.
That on your tie?
I can wait a moment. Sorry, my fault.
Is that okay?
It's fine. You want that one?
No.
Maybe on top of the blue.
Here, I got you.
Sorry
There's a
about that.
wire going over, you can put it on that. They'll both stay there.
Which one are you saying?
There's a wire going over
Right here,
on
right
the
here.
side right there, just on the edge of it.
That's fine.
Sorry,
Can
guys.
you read her entire statement? It was hard to hear your words. Or once we're
Toward me.
All right, hold on.
You're right.
Actually, my mic is not. It's like way down.
Which
You need
one?
me to hold
This guy?
something? You want me to put something in my pocket or hold something?
Oh my gosh. Yeah, can you put these in your pockets? I just got things all tangled, so I guess hold on.
I think you're being incredibly generous and nice about this.
Not a problem. I will say while we're doing this, for your edification, my ethics rules allow that I am allowed to talk on what's on the public record. I'm not allowed to talk about what is not on the public record, which may aid you in the questions you may be asking me. What happened today in the courtroom is on the public record, so I can talk about specifically what was said there. If you're asking me questions beyond that, that is not in the public record, it is not something I'll be able to respond to, and you'll hear me say that. What she stated today, she read a statement. You probably saw her holding it in there. She said, "I learned that Patrick Frazee had committed a homicide on approximately November 22nd, 2018 in Teller County. I knew that law enforcement would be investigating that crime. I moved the victim's cell phone with the intent to impair the phone's availability in the investigation. I had no right or authority to move the victim's cell phone. That occurred between November 24th and November 25th, 2018 in Teller County." That's the statement she gave on the record today.
Dan, in general, how important is Crystal to your case against Patrick?
I'm not going to be able to comment on that question. His question was, how important is she to the case against Patrick? I'm not going to comment on that.
Dan, where's the phone right now?
Again, there's been nothing put on the record of where the phone is today, and I'm not going to comment on that.
Can she help you locate the body?
Again, there's been nothing put on the record, and I'm not going to comment on that. Can you hear all the questions, or do I need to repeat any of the questions?
Being suppressed.
Say that again.
Why are the documents being suppressed?
Which documents are you referring to?
The ones that relate to today's proceedings.
Yeah, he asked about whether the documents today are being suppressed. What he's referring to is, in Colorado at least, we actually do a written plea agreement that she would have signed. That's what the judge had in front of him. That's something that the judge then reviews with her, and she did state on the record she's read it, understood it, and signed those documents. Both parties in this case have agreed that that document will be suppressed, meaning it's only available to the parties in this case, with the exception, and we put that on the record, that it will be provided to Patrick Frazie's attorneys, so they'll be able to see the plea agreement, see the actual attachment A, I think we called it, is that correct? Attachment A that was included on that, which is part of her, spells out the terms of what she's required to do. That was suppressed at this time at the request of the parties.
Why did you agree to the plea?
She's asking, why did we agree to a plea? I don't know that I can comment on that at this time. Maybe a question you can re-ask on February 19th after that proceeding's over, because certainly at that point you'll be provided more information. We've talked about that before. The 19th date is a preliminary hearing. At a preliminary hearing, the prosecution is required to put on evidence for the judge to decide what to bind over for trial, which charges to bind over for trial. So at that time, obviously, a lot more information will be put out in the public realm. So it's probably a better question for that date. I know I think it's a fair question. I'm just being cautious ethically because I think you and certainly others in the public it's a very fair question, one that I think the public deserves an answer on. I just don't think today's the date to answer that. I think that's a question I would feel more comfortable answering here in just, 10 days, 2 weeks, something like that.
Do you expect Krista to testify at that preliminary hearing?
Again, that's not on the public record, so I can't respond on who will testify at the hearing on the 19th. Certainly we are required to actually put on evidence. Certainly we will call witnesses at that. I will say it is not a trial. It is a mini hearing. Generally trials go a couple weeks. These hearings only go a few hours. So it is one that hearsay is allowed at that hearing, and so we can have people take the stand and say, this is what somebody told me, or this is what is indicated in the reports, or these are the results of whatever it may be. So you will find it is a very quick proceeding. Not all witnesses will be called, but at this time it's not in the public realm what witnesses are likely to be called.
What was in that plea agreement that you didn't want the public to know?
Again, that's kind of a two-edged, he asked what's in the plea agreement we don't want the public. Certainly it also provides the opportunity for Patrick Frazie's attorneys to look at that. It can be readdressed on how they feel about whether it should be suppressed or not until a future date. Certainly it'll be provided to them. It is something that may come up in future hearings in terms of what's in there. And so I'll be more at liberty probably to talk about it in the future. Sort of like the arrest warrants and search warrants that have been suppressed in this case. They just haven't been unsealed. I don't think anybody's made the motion to unseal those at this point.
Will they be unsealed on the 19th?
I can tell you as to I have specifically said on the record before that the arrest and search warrants were remaining sealed at our request because the investigators indicated that if it got out in the public, it could affect their ability to investigate this case. That is no longer true. So at least from our perspective, law enforcement is no longer indicating that it would affect their investigation for those to be in the public realm. But I got to tell you that somebody has to file a motion if they want to get access to those. Judge has to rule on it. And in a courtroom, then the defense would have an opportunity to say what their position is on it, whether those should be released or not. We would have an opportunity to put our position, which at this point is it is no longer needed to be sealed for the investigation. The judge would make a ruling. Someone would have to file a motion to say why they want it released, and there's a balancing test. I've had that come up in other cases, so that's the status of that right now. Obviously, the next court date is April 19th, or excuse me, February 19th. Excuse me.
Can you give us an update on the
I can, his question is, can I give an update on the search for Kelsey's body? Again, that's not something I can comment on. It may be something you could ask the police department about, Woodland Park Police Department, but I have a very strong feeling that they're going to say the same thing I am right now, which they can't comment on it.
Because it was a little hard to hear in court. Can you, it was a little hard to hear in court. Can you go over what we do know about the plea agreement again? Just from what was talked about in court?
Sure. There was a summary of the plea agreement that was put on in the court. She's asked to repeat that because you had a hard time hearing that in the courtroom. And it is a historic courtroom, so I understand the acoustics are a little difficult in that particular courtroom. It was put on the record that the summary was she did plead guilty to a Class 6 felony, tampering with physical evidence, that she is required to cooperate. The judge asked, was she required to cooperate with the investigators and prosecution at any time, and it was indicated she is. The judge asked, is she required to testify in the future at any dates that she's asked to testify, and it was indicated she is required to do that. The judge noted on the record that she's not allowed to talk to the press as part of her plea agreement, he did state that sentencing will be postponed until after any cases that are involved in this case, and that could be anywhere from 6 months to 2 years. I think there are a couple other things, but that's kind of off the top of my head, some of the main things I think you would want to know.
Is she free to come and go?
And actually, Jennifer, were there any other things that... Say that again?
Is she free to come and go? Is she?
The judge did state on the record that she is not being taken into custody, that she is free to come and go at this time. She has a requirement, obviously, to keep touch with the court. We do have review dates when she has to have contact with the court, and she is required at some point to report for sentencing. The judge indicated in our system, actually, when you get to the sentencing stage, that you actually meet with probation. They do what's called a pre-sentence report for the judge to have. So that, again, has been postponed. So at some future date, she'll be required to report to probation to do a pre-sentence report before the judge decides what the sentence would be. She would be required to show up at her own sentencing. She would be required to show up at any other court hearings that she's requested to be to. So that's what's required of her at this time. Otherwise, there are no other obligations that she has in terms of where she has to be.
Will she go back to Idaho? Will she receive any protection?
She was, what was filed, what was given to her, I think it was stated yesterday. Yeah, it was stated that yesterday she received a felony summons. Felony summons is a law that was passed a few years ago, about 3 years ago, 4 years ago in Colorado, that on Class 5 and Class 6 felonies, you can do a summons rather than an arrest. And she was given a summons, meaning that she was not arrested yesterday, and then the court was given a copy of that also. The court did inquire whether she had had fingerprints and a photograph taken. The defense attorney on the record, as I recall, said that had already been accomplished. I know that actually the media has been asking about that particular photo. That is available through the Colorado Springs Police Department. Yes, through the Colorado Springs Police Department. So they're the ones who did that, the photographing and fingerprinting. So if you want to contact them, I'm told they may be putting it out.
It's out now.
Oh, it is out on.
It's out. It's on their Twitter account.
It's on their Twitter account, and that's really making it available to the press
What is Crystal's demeanor
and the
then?
public.
What is Crystal's demeanor then as you and your team is?
Again, I can't speak about things that are off the record. You saw her demeanor today, and you can elaborate on that as easily as I can.
Can you say whether or not she was threatened by Patrick Breezy herself?
Again, I can only state what was put on the record. It was not put on the record today, the question that you're asking.
Assuming she does what she's supposed to do, testify in future trials and the things, and she's cooperative, assuming she meets all those things, is your office likely to put in a good word for her at sentencing? Is there anything like that?
Again, the only thing that was put on the record is, by Colorado law, this particular charge is a charge that carries no mandatory sentence at all. It is something that will be totally up to the judge. And the court noted on the record that both sides will have an opportunity at her sentencing to express our opinions on what she ought to face, but ultimately it's up to the judge in terms of what he wants to do. The sentence, again, ranges anywhere from probation into the presumptive range of up to 18 months in prison, and the aggravated range up to 3 years in prison, and then, again, that's strictly Colorado law.
Outside of what happened in court, what's on the record, personally, how would you describe it?
Yeah, say that again.
Personally, how would you describe
And then I'll come
this
back to
case?
you. What?
Personally, how would you describe this case?
Personally, how would I describe this case? That's a pretty broad question. I'm not sure I'm going to be able to answer that for you. If you want to think of another way of
Well, I mean,
asking.
you know, I'm just trying to get something about, you know, this is obviously a tragedy, you're investigating it, something that's not official record.
I know that I previously talked certainly when Kelsey was a missing person, we were all hoping this would end much more favorably than it has at this point. It's a horrible tragedy for their family, horrible tragedy for our community. Obviously, it's caught the attention and the heart of people across the country and actually maybe across the globe. So I've already expressed that on the record at the time that we were hoping to find her alive. And unfortunately, it didn't go that direction.
Can you explain a bit about the aggravating factors, what that means, and how a court might determine whether they or not?
Sure. Under Colorado law, in our sentencing scheme, he asked to just explain what our sentencing scheme's like with aggravating versus presumptive versus mitigating, actually, also. Under Colorado law, every felony is divided into felonies from 1 to 6, and each one carries a certain range. Under Colorado law, we have what's called a presumptive range, and that's sort of what is presumed the judge would do in a normal sentencing, sort of comparing it to other cases, other factors in it. And that would be the presumption of what that sentence would be. And then in this case, that is up to 18 months in prison. And it would also include, I guess, in the presumptive range, ComCore, which is a halfway house, or probation. The judge specifically said he could give a halfway house, for instance, up to 18 months in that. If the judge should find extraordinary aggravation, which is defined under Colorado law, then it would permit the judge to go into the aggravated range, which in this case would be up to 3 years in prison. But again, the judge would actually have to factually find under our law that there is extraordinary aggravating factors. Even with finding that, it is not mandated that the judge give a sentence in the aggravated range. It's still in the end up to the judge. So even finding factors like that, the judge could give any sentence that he feels is appropriate at that time, anywhere from probation on up to 3 years, even if he found those factors. If he did not find extraordinary aggravating factors, then by law he is not allowed to go above 18 months.
Can you describe your negotiation among your own team, how you settled on this one charge, you consider other charges, you weigh or value, and cooperating with your prosecution? Can you talk a little bit about how you zoned in on this one charge?
She's asked a number of questions in a row there, but primarily it was talk about the negotiations in this case, talk about how we arrived at this particular charge in this case, and what was in the negotiations. I cannot comment on that. There is actually specific laws regarding that. Negotiations are considered private matters to the extent that even, well, we'll see, but typically not even other co-defendants are allowed to know what happens in negotiations of fellow co-defendants. It is an area of the law that is protected of how the negotiation process happens, so I can't comment on that at this time. Now, it may be that certain aspects of it, I think, again, coming back to your question, I think there is a fair public question there. It's just not at the stage that I think I can comment on it. Yours, I can never comment on the negotiations themselves, but what the state, I think it's fair to ask what the state, I forget exactly the way you phrased your question, but it was something about, what did we consider, why did we do this? I think that's a fair question at some point. It's just not one I can answer today, but I think it's one that needs to be answered at the appropriate time.
Can you comment on their relationship, the relationship between Kenny and Frazee, and then maybe her motivation for this crime she pled guilty to today?
She asked, can I comment on her relationship and motivation for the crime? I cannot comment beyond what's in her statement, and I've done that a couple times now. Say that again.
Is law enforcement still planning to search the landfill site in
Is that out in the public?
No,
I don't believe anything's out in the public at this time, so again, I can't comment on that.
Can you say that whether or not the charges to commit, solicitation to commit murder, the 3 charges against Patrick Frazee, is Crystal the person he solicited?
I don't believe that the charges are out in the public realm. I don't believe those charges carry the name. They do not carry the name of the person solicited. Obviously, at the time we do the preliminary hearing on the 19th,